This question is an audience question posed for Mrs. Coon. What position would Arkansas be in now if Roe versus Wade were to be overturned?
What position would Arkansas be in if Roe versus Wade would be overturned?
That is the question.
I apologize if I don't quite understand the question. Of course, it's a hypothetical because, as we all know, Roe versus Wade is there and it's law. Justice Scalia was actually asked about his religious preferences and the fact that Roe versus Wade is there, and he said that, in his mind, if you read the Constitution, it is not consistent with how he feels. And so the Constitution currently is that it allows states to ban abortion. I think that is an issue that, because that's the case, I think that's an issue that would have to be decided by our legislators. And so that's why you and I are going to vote for the legislators that we believe represent our opinions. So, I agree with Mr. Hixson. The judge's role is not to legislate. I've got a TV commercial that's coming out tomorrow that says, "I will not legislate from the bench if I am allowed to serve." And I think that is a question that Jeremy or Bob or Bill or Ryan are going to have to address for the people of Arkansas.
Thank you.
For Mr. Hixson, how would you shorten the time and complexity for resolving cases on appeal?
So y'all heard that. How can we shorten up the time to resolve cases on appeal? It's a difficult proposition because the Supreme Court has rules that are designed to make sure that every litigant has a fair day in court. The first thing that happens on the Court of Appeals case or Supreme Court case is that the local circuit clerk, the court reporter, has to prepare a transcript of usually every word spoken. It depends. If it's a one-day trial, you can get that transcript back in 45 to 60 days. If that trial happens to be a week-long trial, it will take the court reporter 4 or 5 to 6 months to just prepare the transcript so that we can mail it to Little Rock to even start the process. There's a rule in place. It used to be 9 months that the transcript has to be prepared in 9 months. And if it's not prepared in 9 months, you can file a petition to enlarge the time. But the first step is really out of the attorney's control and the court's control. And that's how long it takes the court reporter, who's very busy typically, to get the transcript prepared. Once the transcript is prepared, we lodge it, is what we call it. We lodge it in Little Rock. We pay the filing fee. And after that, typically one side has 30 days, the appellant has 30 days to file the initial appeal. 30 days is not that long a time. It may sound like a long time to y'all, but by the time we get the transcript back, review the hundreds of pages of transcript and see if it's accurate, to glean what we want to pull out of it, and then to prepare our arguments and type it up, then 30 days is not very long. Then once we send it to the other side, then the other side has 30 days to prepare their response. Again, not an unreasonable time frame, in my opinion. Once we get it back on our side, we have 15 days to file a reply to their response. So at that point, you have 30 days, and 15 days. You have 75 days built into the system after we get the record from the court. So the question, how do we shorten it? I don't know how you would actually shorten that time period, because we have to get the record from the Court of Appeal, the court reporter, and she may have 2 or 3 appeals going on at the same time. So we're totally dependent on what the court reporter does. But once we get the record, that 15 days is a reasonable time to get the thing to the Court of Appeals. I think where the delay takes place is once all the briefs are in the Court of Appeals, and then how long does it take for them to get the answer back out, get the decision back out? You heard Judge Hart said she's done she's written 1,000 opinions and has heard 3,000 cases, and it takes time. I understand. I saw statistics from 2010. It's the last year that the statistics are available. The Court of Appeals heard 900 cases in 2010, and it is a heavy caseload. I would love to say that there's a magic wand to shorten that time frame, but when you're handling 900 cases between 12 judges, and you have to read briefs, at least 3 briefs on each case, I don't know where you can chisel that time down from. I don't think there's any way you could make a court reporter prepare the transcript faster. The 15-day period is a reasonable time frame, and I think it's something that we both may learn. Is there a way to speed up the process once the court gets it? It's very frustrating, because I've had cases in Little Rock as long as 2 years. I've had cases in St. Louis for 2.5 years, and everything is in limbo. But is there a magic wand? Is there a crystal ball to shorten that time? Personally, I don't see it. I hope there is, but it would surprise me, to be honest with you.
May I add something, or
Sure.
do I just keep it?
If you want, you have something else, go ahead.
I was just gonna say, in my experience, as far as appellate practice goes, I agree with Mr. Hixson, there's that, time period.
Mr. Hixson, should appellate judges be concerned with the ultimate result in a given case? And why?
Yes, well, we have to be concerned with the ultimate result in any case, but I believe the Court of Appeals has to have a broader look. The circuit court is concerned with the ultimate outcome of any case, and they apply the practice law initially. If either side appeals it, it goes to the Court of Appeals, and we have to be concerned on how we have to first apply the law in the state of Arkansas. We can't allow our prejudices, our biases, what we think the law should be, what we think the outcome should be. We have to apply the law. To interpret the law, not to make the law. So on the one hand, I can appreciate the question, should we be narrowly concerned with the litigants, each conclusion with the disposition of that case. But I don't believe the Court of Appeals can solely look at that one person's case. We have to apply the law of the state of Arkansas, knowing that future cases, we have a principle, the judge call it stare decisis, or you can call it precedent, and we have to apply the precedent of the law of the state of Arkansas. And so I think not only do we have to care for the disposition of that case, we have to be on the lookout and to be very aware of how our cases will affect future litigants.
Do you have anything to add to that before I go on?
Yes, no, I'd agree, that the Court of Appeals' job is to look at a controversial result in a certain case. as I mentioned earlier, the Arkansas Supreme Court, so the Court of Appeals was actually created in 1978, somewhat lighten the load of the Supreme Court. And so the cases that don't seem to impact more than just the litigants are what are brought to the Court of Appeals. And as I said earlier, the Supreme Court still has what we call exclusive jurisdiction over those handful of cases, the constitutional law cases, death penalty cases, and then they can reach out and grab whatever else they want to that they think may impact more citizens of Arkansas than just the litigants. So I think that the Supreme Court has that job is important at the Court of Appeals level, but it's even more important at the Supreme Court level.
The next question is we'll ask you first and I'll let you respond to it. How important is precedent in deciding a case? At what point do you say maybe precedent is wrong? And how do you decide that?
As Judge Hart said, precedent is very important. I would say that precedent is analogous to our Constitution. It's the law of our land, it's the law of our state, and that's what we should, as judges, work to uphold. Just like the statutes that are written by our legislators. A judge's role is to uphold those statutes and make sure that they are followed. Likewise with precedent. If the Supreme Court of the United States has said something, it is up to the lower courts within our country to uphold what the Supreme Court has said. And likewise within the state. If our Arkansas Supreme Court has said what should be, then as an appellate judge at the Court of Appeals, it's our job to follow what's been ruled on by the Supreme Court.
One thing I would add to that is that seldom are the cases before the court exactly like the precedent. It's what we'd call it is a case on all fours. Is it exactly alike? If the case is on all fours with the precedent, you have to apply the precedent. It's easy. But what I've learned over the years is that none of them are the same. The facts are a little bit different in every case. One guy said this, one guy said that. The light was green, the light was red. The boundary line was here, the boundary line was there. And I think the art and maybe the science of the appeals court is to take the precedent and apply it to the facts in front of you. If it's clearly on all fours, it's an easy question. Not much easy out there. I'm sorry. If it's easy, it probably didn't get appealed to start with. There's a lot of gray in our world. And whether you're teaching science or you're teaching math or you're applying the law, I think where experience and wisdom and temperament are very important is to apply the principles. Can we apply the principles of the precedent to the case before you? And I think while it may appear that you get a different result out of the same case, when you look close at the opinion, there will be a different fact that a judge went off on so that he could draw a different conclusion. And I believe that that's the art and the desire, the need to have experience so that you can read these cases, apply principles, but apply those principles to the facts of the case, and therefore you can have precedent, but you can have varying answers to that.
What about this, I'm sorry?
I'm sorry, go ahead.
No, do you have a
Can I ask
question?
you a question? Ladies first, if you will. Can you tell us the main difference between you and your opponent? And same for Mr. Hixson, please.
The main difference, and of course, I did not know Mr. Hixson until
No,
I
and I'm not
campaigned
asking you
started.
anything negative.
right.
I guess what I'm saying is from a voter standpoint, I don't know about everybody else in the room, but from a legal standpoint, I am really in the dark. What I'd really like to know is what separates our two candidates, if you can.
Absolutely. As I said, I have been practicing law for 16 years, close to 16 years. Graduated in 1996. And I can tell you that in those 15 plus years, I am proud to say that I have done as much, if not more, than a lot of lawyers that have been practicing law much longer than I have. I have, as Mr. Hixson has, I've tried jury trials, I've tried bench trials, I've had lots of hearings before judges. I've handled appeals, as I said earlier, in the Court of Appeals, the Arkansas Supreme Court, as well as the federal system. But in addition to all that, I've also been involved in the profession in other ways. For example, there is what we call the Arkansas Bar Association, and some folks may not be familiar with that. It is a voluntary group of lawyers, and we provide services to the profession. So we provide continuing legal education, and we provide support, and that type of thing. The Bar Association has what's called a House of Delegates, which I would compare to Congress. It has a Board of Governors, which I would compare to the Senate, and then it has a President of the Bar Association. And while I'm practicing law, I have also served on both the House of Delegates for 2 terms, as well as the Board of Governors for 2 terms. So I've been involved in the Bar Association. I've also taught classes in the paralegal legal assistance program at Northwest Arkansas Community College, and Rogers, Bentonville. And I continue to stay very active with the law school, because I think being involved with the young lawyers that are coming into the profession is very important. So I try to judge competitions that they have at the law school, and I speak to the students during orientation as often as I can. And then finally, the last thing I'll mention is something that's called the Arkansas Supreme Court Professional Practicum. So about 6 years ago, our Supreme Court said our profession has a very negative perception. So we are going to require every lawyer that gets a license in Arkansas to take a day and spend it on professionalism and ethics. So every person that gets a law license now, within the next 2 years, has to spend a day with certain faculty to talk about respect and how to deal with lawyers and how to deal with judges and how to deal with clients. And the faculty for the professional practicum is selected by the Arkansas Supreme Court Committee on Professionalism. And I have been honored to be asked by that committee in 3 of the last 4 years to serve on that practicum faculty. And the 1 year I missed it was because my mom was in the hospital. So this goes back to the working hard part of my campaign that I said early on. I promised to work hard, to play by the rules, and my motivation for running is service to our community. I have worked very hard in the 16 years that I've been practicing law. And I think that that, along with my motivation for running, sets me apart.
Your response, Mr. Hixson?
Sure. Let me start off by saying I have been a practicing lawyer now for 30 years. And one thing I've noticed in my personal life, my private life, my professional life is I'm better than I was 15 years ago. I'm a better husband. I'm a better father. I'm a better lawyer. And that's because I've seen things in the last 15 years, the last 30 years. I've grown. I'm not a hothead anymore. One judge told me I was histrionic about 15 or 20 years ago, and I appreciated that. And I think when you put that together, how do you attain wisdom? What's the difference between wisdom and education? It's experiences, real life experiences. You not only am I practicing law, I've been a past president of the Northside Rotary Club in Fayetteville. I'm a past member of Habitat for Humanity. I've been on several boards. I led the stewardship committee for First Baptist Church in Fayetteville. I've been on the planning committee, I've been on several church committees. Butterfield Trail Foundation is a nonprofit charitable organization. It's a retirement village. I've been on that. I've been on their personnel committee. And I think it's important not only to have a sound basis in law and have a sound basis in the court system, but have a well-rounded basis in your community as a whole. And I think when you put all that together, I think it's important to be well-rounded. And I would like to mention one thing on legal ethics and continuing legal education. We do have what's called continuing legal education, and while it may surprise some folks, we do have rules of ethics. Sometimes I wonder, I'm as dismayed as what some lawyers do as y'all are. It's embarrassing. The advertising is embarrassing. The way some lawyers act is embarrassing. It demeans the profession. I don't like it. You can do it. You have the First Amendment right to do it. I don't like it. I've taught ethics. There's continuing legal education. And I've taught ethics 3 times for continuing legal education. I've taught evidence twice for continuing legal education. I've taught advanced human resources and employment law at NWAC. And I tried the first case in the 8th Circuit on anti-discrimination law. And I think what makes the difference is experience and temperament and the ability to cut through the fog and get to the bottom line. And I believe I'm well equipped to do that, and I believe I could start tomorrow.
Very good. In the interest of time, this will be the last question. Mr. Hixson, I will address it to you first. Please keep a short answer. What is the most important tool a judge can use in resolving a case?
Wisdom.